Okay, good evening, good afternoon, good morning, whatever time that you are watching this video. I am Richard Taylor, and I'm coming back with a video that points to the total miscarriage of justice that was handled in the case of Miss Kolanda Wooten. I interviewed Kolanda Wooten yesterday. Kolanda Wooten was 17 years old in 2023, where she was involved in an act that took the life of another person. She was not the person who took the life, but she was at present, and she received, at the age of 17 years old, life without the possibility of parole due to legal precedents that changed the law. She was released in January of this year after serving 20 years of that sentence. Now, you can go back and review the interview from yesterday if you want to hear her story and a little bit of details about what happened. But what I'm here to focus on in this video and recap is the total miscarriage of justice that the 17-year-old Kolanda Wooten received by the Wayne County judicial system, namely District Attorney at that time, Mr. Matthew Delbridge, who tried the case, also Judge John Smith, and also her inefficient defense attorney, Mr. John Reese of Smithfield, North Carolina, and the total Wayne County justice system in totality. Now, why do I say that? I researched some articles about the case back then, and I realized two distinct things that happened in this case that denied Miss Wooten her lawful right to a fair and unprejudicial trial. And that was one, they tried the defendants jointly. That means they had one trial for two people, which totally prejudiced the jury against Miss Wooten because she did not commit the act, but the jury has no ability to compartmentalize all of the information that they heard throughout all of the case and to be able to separate the fact that the one who committed the act that took the life acted totally different, and the evidence was totally separate from Mrs. Wooten's alleged role in the act. Now, the second thing about this case, and you can look it up, is it says Miss Wooten's lawyer, Mr. John Reese, did not put on a defense. Period. That means Mr. Reese did not call any witnesses, did not call Miss Wooten to the stand. Therefore, he relied on all of the evidence presented by the state against her co-defendant and her, and only the defense put on by Mr. Jeff Hoss. He's culpable too. I hope I mentioned him. Jeff Hoss. He was the other defendant's lawyer. So he put on information defending his client. But when it was time for Mr. Reese to call and defend his client, he didn't put on no defense. So therefore, the only thing that the jury had to go on is the evidence that Matthew Delbridge presented against her co-defendant, but also against her, because while he was presenting evidence against his co-defendant, he was also implicating and saying, why should she be charged? Why should Ms. Wooten be charged with the same first-degree murder that her co-defendant was charged with, which is totally, it's insidious what they did to this young lady. And the fact that you know that it is insidious and is intentional because on about 6 or 7 or 8 years later, when Mr. Matthew Delbridge was running for the head district attorney's office, he used this case as a benchmark, as a campaigning tool to be elected to the office. I'm going to show you this picture. This is and you can't see. Okay, hold on, let me see. If you read it, it says Delbridge for district attorney. This is a Facebook post that he made in 2014. Now you see the caption on the screen, I guess, in the thumbnail. But this post reads: Jury trial, Wayne County. Found guilty of first-degree murder and sentenced to life imprisonment on April the 19th, 2005. For the defendant, Michael Reese. For the state, Claude Ferguson and Matthew Delbridge. So he's using this picture as this young 17, 18, 19-year-old girl to show the public that he has been tough on crime. There you see the Facebook post. He uses this case in which the case was not even heard properly. And it was a couple of comments. One lady commented, Claude remembers this case. Now, Claude was also a district attorney, and he remembers how well you guys did in trying it. How well you guys did, you didn't have to try anything. Mr. Reese didn't put on a defendant, especially for this lady. So it is incomparable. It's unfathomable. It's almost disgusting, Mr. Delbridge. And please, somebody send in this video, because I try not to get excited or enraged when showing this, but it is insidious that you know that this woman was not even the person who committed the act, but you're going to use her face, her likeness, to say, yeah, I convicted this person for first-degree murder and sentenced her to life imprisonment. So elect me because I'm tough on crime, when you know that this 17-year-old probably didn't deserve to be even sentenced or even convicted in that manner. She definitely should have gotten a better trial and trial defense, because actually, if you watch the video yesterday, Ms. Wooten asserts that they did offer her a plea for 8 to 10 years. And she rejected it because she was like, I didn't shoot anybody. I didn't know what was going to happen. And at 17 or 18-year-old, I agree with her. Now, if she would have known that her lawyer wasn't putting on a defense, she probably would have thought differently, because once again, if you watch the video, she was going off everything that her lawyer had said to her. And in the video, she said that her lawyer continuously said, you don't have anything to worry about. Mr. John Reese continuously said, you don't have anything to worry about. But yet he didn't put on a defense. What lawyer, and all the legal and political pundits can bring me all of the reasons and justifications for this lawyer not doing so, but anybody with one good eye can see that this was a total miscarriage of justice. Now, mind you, all of these people, Judge John Smith, Attorney Jeff Hulse, Matthew Delbridge, all of these guys go out to eat together. They play at the same golf course. So this is something that was decided beforehand. They talked about this. And I'm going to read you something from a journal. It says, Joint Trials, Judicial Inefficiency. It's judicial inefficiency for the defendants, but it is economically efficient for the court administration. So these guys talked about, we're gonna try them all together, and we're going to not put on a defense, and we're going to get this conviction. And as you see, because of this conviction, it allowed Matthew Delbridge to move up in the ranks, because once again, the DAs advance their careers by how many convictions they get, and also how much man hours they sentence a person to prison. And as you see right here, this is Matthew Delbridge advertising this case in 2014, excuse me, on why he should be elected the head district attorneys, in which he is right now. But let's talk about, first of all, the reason that they try these things jointly. First of all, it's economically efficient for the courts. Because if you have two different trials, that means you have to have two different juries, you have to have two different judges, you have to have all witnesses come each trial, you have to have, you have to take up the court time. All of these things factor in. But what it does is, if you have two separate trials, it allows the jury to hear each case individually and to make a decision on each case without the defendants being prejudiced by the acts of the other defendants. And they're going to talk about this in this article. I'm just going to read a couple of things from this article. It's called The Joint Trials, Judicial Inefficiency. And as I stated, joint trials are believed to promote economical and efficient judicial administration. Like I'm saying, efficient and economical judicial administration. It costs money to have a trial. It costs money to pay jurors. It costs money to pay each different district attorney to tie up courtrooms. So in this case, you see that they didn't want to do that. But more importantly, we're going to see how joint trials, they are put on to prevent inconsistent verdicts. Meaning, when you have a joint trial, if one defendant gets convicted, the other is likely to get convicted. Even though that they have two different roles, two different set of circumstances in the charges, they're going to be convicted off of the basis of the actions of the other, which we see that Miss Wooten was convicted off the basis of her co-defendant. I'm going to read a couple of more lines from this article to let you know what they're saying. And this is my point right here. It says proper joinder nevertheless may be prejudicial to a defendant, and it is prejudice to a defendant's right to a fair trial. Meaning, how can Miss Wooten have a fair trial when the jury is hearing all of this information about her co-defendant and trying to, they're automatically, now jury people are smart, but most jury people are lay persons, working people with no legal experience. They're not versed enough to be able to compartmentalize or separate which information should be applied to this defendant and which indefendant information should be applied to this defendant. And that exudes in this case, once again, especially when Miss Wooten's lawyer didn't even bother to put on a defense. It exudes to a miscarriage of justice, as it says in this document. Now, also, it goes on to reiterate on page 328. It says 10. Simply stated, joint trials are beneficial. They are more economical than severed trials. The common wisdom is that joint trials avoid inconsistent verdicts and present the jury with an overall picture of the crime. So there you have it again. These jurors have an overall picture. They don't have how each person within that picture is not as culpable, is not as responsible for the other person. Once again, they're joining and they're lumping everything together which once again prejudice the defendant. Like I said, it says the prosecutorial inefficiency. He said this assumption is supported by the underlying belief that the evidence relating to each defendant is virtually identical and results from the same act or series of acts. Now, if you're driving a car and you don't know somebody is going to shoot somebody, your actions are not identical to the person who shot the individual. But that's what they're trying to say, or that's what they tried to say in Mrs. Wooten's case. Now, once again, I'm not going to get into the details of the case. I'm just talking about how the case was tried. And it goes on, let me see, page 14. It talks about what I was talking about as well. Witness efficiency. They saying jointers can be more efficient. Joint trials can be more efficient since it lessens the burden imposed upon witnesses to keep coming. It lessens their responsibility to tell the same story over and over and over again. What about the defendant in this case? What about their trial efficiency? You know, they're talking about, and once again, we know that the joint trial is just to save the state money, you know, and we know that court is a business, but that is what they're trying to say, that it makes it easy on the witnesses. The witnesses are not important. The important thing is that the defendant, in this case, Ms. Wooten, would get a fair trial. Now, this other page goes on to say and talk about, I need some water. Consistent verdict justification. What they're talking about is, once again, they support joint trials because separating trials fosters inconsistent jury verdicts and unequal treatment of legally indistinguishable defendants. Now, once again, an inconsistent jury verdict, if that verdict is right, it doesn't matter whether it's inconsistent or not. And then it's talking about defendants who are indistinguishable. The defendants in this case were very distinguishable. You know, one who commits an act and one who's just driving without proper knowledge or preconceived knowledge that this act was going to occur. And also, it goes on to point once again about the overall justification picture. Once the whole picture is before the jury, they can consider the full impact of the involvement of each defendant and determine his relative culpability. The jury's ability to judge the relative culpability of each defendant is only as effective as its ability to compartmentalize. That means to separate the evidence relevant to each. In the context, they said that, and the way that they can do this to make sure the jury is able to do this is to make sure they get the proper instructions before deliberation. Now, if you watch the video, well, she didn't mention it, but in the article, it said that the jury, even before they went in, they asked the judge, well, can Miss Wooten be convicted of a lesser crime? So that right there lets me know that they didn't have the ability to decide for themselves because they had to ask the judge. So these people, these juries, are not able to take all of this information all of the evidence that was submitted in this one area against this person. They were not able to take that information and separate it and say, well, nah, she definitely shouldn't be charged with first-degree murder, because if they had that ability, they wouldn't have had to ask the judge. They would have known. So that's where this system is double speaking. But also, once again, it also talks about the equitable cost of joint trials. It is purportedly more efficient than separate trials because it conserves judicial resources while minimizing the burden placed on the court and on the jury. But the burden, of course, is supposed to be on the court. So why would you minimize that burden and place Ms. Wooten in a adverse position with another defendant where their total roles are very distinguishable? So once again, they did this joint trial to pretty much say, okay, well, look, we know we're going to convict him. Now, even though that she is no way as culpable, as responsible as him, if we convict him, then of course, if we do it jointly, they're going to convict both of them. Because once again, the only evidence that that jury had to decide whether Miss Wooten was innocent or guilty was the evidence presented about the person that she was with. Because her defense, Mr. John Reese, did not put on a defense. That is horrible. There's no way that anybody watching this video here, now, or thereafter can tell me that that was a fair and equitable trial for Miss Wooten. I'm going to read about a couple of more. What is that on page 21? And then I'm going to let y'all go. But I just wanted to recap this and show you the evil of this system. The evilness of this. And then it talks about, jurors. They're being, their lives being interrupted. It doesn't matter when we're talking about the life of a 20 years of the life of this woman who was definitely not given a fair trial. Those jurors are going to be out of work for 2, maybe 3 weeks. So instead of 24 people being out of work, we're just going to make 12 people be out of work and hurry up and get this thing over with. This last thing I'm going to read once again is about the equitable cost to the defendants. It says the ultimate test of complexity on review is whether the jury can separate the elements relevant to each defendant. And that is my whole claim of this video. The ultimate test of complexity. Now, this is the legal journey asking the question and even pointing out is whether the jury can separate the evidence relevant to each individual defendant. Now, it's clear that they couldn't because they asked the judge, could she be charged with a lesser crime? Now, the judge said yes, but they still came back with a guilty verdict. That means they were not able to distinguish, look, this person shouldn't be charged with first-degree murder. But because we convicted this person, then we have to convict this person. Even Ms. Wooten said it in the video. She said once they said the guilty verdict for her co-defendant, she knew that they was coming back with a guilty verdict for her. But it's just, once again, it's unfathomable that Mr. John Reese of Smithfield would not put on a defense. And of course, he was probably told not to. Once again, because of time, because of efficiency, and because of the consistency of verdicts that Mr. Delbridge wanted, Judge John C. Smith wanted, Attorney Hoss wanted, because there's no way that this young 17-year-old girl, speaking to her yesterday, and I know if she would have been on the stand, I've been on trial for the rest of my life, and there's no way in the world that my lawyer was going to let me not speak. That jury had to feel me. They had to hear me. And there's no way in the world if that little 17-year-old girl would have been put up there with her demeanor and, her innocence, basically, there's no way that jury would have convicted her for first-degree murder. Now, of course, once again, John Reese told her all the while, no, you have nothing to worry about. You have nothing to worry about. But he knew, as a 40 or 50 or however old he was then, that jury did not have the legal capacity to separate the evidence that was presented against her co-defendant and separate it and judge her solely on the evidence presented for her which, as we see, there was no evidence presented in her favor. Mr. Reese did not put on a defense. And so that is the miscarriage of justice here. Anybody watching this video, y'all, if y'all got a contradiction, call me directly. 919-587-7782. This lady should be suing everybody right now. Because there's no way that Laurie should have put on the defense, but also there's no way that they should have been tried together. But once again, all of this is a further plan because as we see here, Matt Delbridge, Kolanda Wooten, Matt Delbridge for district attorney. Now this is a Facebook page. Now you can go look it up. He's advertising. I committed this woman for first degree murder in 2005 and she was sentenced to life imprisonment. And her attorney was the dishonorable Michael Reese. So Delbridge has won the office, but why would you use this picture of this young girl who was not the main perpetrator of the act in your campaigning efforts to become district attorney, man? That's very soft. That's very cowardly. That's very deceitful and insidious. Matthew Delbridge, I'm talking to you. Call me direct as well. 919-587-7782. Somebody send him the video. Screenshot it. Whatever you got to do. Share it. Share it on his Delbridge for district attorney page. Because he used this picture right here of this young girl to further his political career, and also he used the double conviction to further his political career. These guys are evil down there, man. You guys are evil. You can't tell me nothing. Horse, you too. I know you. I mean, you was my lawyer a couple of times, but you know, all of y'all are in concert together, just like the phrase that y'all use to try to convict or to convict Miss Wooten. In concert. You guys are working in concert together. Judge, jury, the judge, the prosecutor, the DA, the defense attorneys, the court-appointed attorneys. All of you guys are working in concert to continuously pervert justice. This was a perversion of justice, and the Bible speaks against this. Woe to you, rulers who pervert justice. That's in the prophets. I don't know which one it is. Isaiah, Jeremiah, or Ezekiel. Either one of y'all, but this case right here speaks of just the man, I can't even think of a word right now. This monstrosity of what we call justice here. Definitely a miscarriage of justice. So I'm glad that my girl, Kolanda Wooten, is out and able to tell her story. But this should be exposed on how they did not even put on a defense for this young lady and tried her in concert with an individual whose role in the crime was totally separate than hers. Knowing that the jury did not have the mental capability or the legal understanding to realize, okay, we don't have to convict her of first-degree murder. We can convict her of accessory or what have you, whatever it is, but first-degree murder without even putting on a defense. John Reese, whoever you are, if you are still living, I hope whatever God has for you has for you. If you are deceased, I hope you're rolling over in your grave right now listening to this, because man, there's no reason that you can explain why you wouldn't even put on a defense. I'm not saying put her on the stand, but put on a defense. Give her a fighting shot at freedom. Nevertheless, this has been the video. I hope I got everything out that I wanted to get out. It's hard doing these videos when, I try to be calm and speaking eloquently and thinking before I speak, but matters like these, they enrage a fire in you when you see and of course she's 17. She, her living situation. I think she was staying in Courtyard, which is a low socioeconomic level. So she probably didn't have any advice. She probably didn't have anybody to advocate for her in that manner, to talk to those lawyers and say, no, wait, no, you're going to put on a defense. You just not going to sit there and say nothing. So that's what this system does. It eats it eats the lowly up. It eats them up, man. So, I hope once again, Matthew Delbridge, you are wrong for that, man. You are a coward for using that picture of that girl that didn't receive a fair trial as an advertising, as a campaigning point for your receiving the current office of district attorney. That's low, man. I can't even think of the word. People say that you are a good guy and you're a scrabble bro. Man, I'm telling you, that and I understand it, because you're playing off people's emotions, especially people in the dominant society who say, yeah, get that little black girl off the street. Yeah, Matthew Delbridge, that girl was a murderer, not knowing the complexities of the case, knowing that she should never have been convicted for first-degree murder, more or less given life without parole. Man, I gotta end this video because it's just so much to say. I hope y'all got the point that this lady was, first of all, this 17-year-old was tried inequitably by having her trial jointly with the co-defendant. She was also represented inefficiently. Who does not put on a defense in a first-degree murder case? Can't no legal, and I got some lawyer friends. My girl Tiffany Lawson, Rebecca Cannon. I met John Hunter there. Can't one of y'all call me and justify. If there's a justification, y'all got my number. 919-587-7782. And last but not least, Mr. Matthew Delbridge's despicable act of using Miss Wooten's photo for pretty much a campaign ad, knowing that this young lady didn't get a fair trial. I'm out, man. Y'all have a blessed day. Peace and blessings. Stay out of the system. That's it, I guess. I'll leave with that. Stay out of these people faces down here at William Street and any street that the courthouse is on in your remote area. Peace and love.